Defining the Annual General Meeting, AGM, a cornerstone of corporate governance. An annual general meeting, or AGM, is a yearly gathering of a company's shareholders, where they come together to discuss and decide on important matters. It is a fundamental element of corporate governance, providing a platform for dialogue, decision-making, and ensuring that the voices of shareholders are heard. AGMs foster transparency and accountability by allowing shareholders to interact directly with the company's management, bridging the gap between the two. They can raise questions, express concerns, and exercise their voting rights on crucial matters, such as electing board members or approving major corporate decisions. The AGM serves as a forum for shareholders to review the company's financial performance, scrutinize reports, and understand the financial health of the company. They also discuss future plans, strategies, and hold the board of directors accountable for their actions and decisions made throughout the year. This annual gathering ensures that the company operates in the best interests of its shareholders, promoting good corporate governance and ethical business practices. AGMs are not merely a regulatory requirement, they represent a vital aspect of a healthy and transparent corporate culture where openness and honesty are prioritized. By facilitating open communication and shareholder participation, AGMs contribute to building trust and confidence in the company's leadership and strategic direction, ensuring alignment with shareholder interests. In essence, AGMs are a cornerstone of corporate democracy, empowering shareholders to actively participate in shaping the future of the company they own, making their voices count. This active participation is crucial for fostering a sense of ownership, responsibility, and aligning the interests of shareholders and the company's management, ensuring long-term success. The Companies Act 2013, setting the stage for AGMs. The Companies Act 2013 in India lays down a comprehensive framework for governing companies. This Act includes specific provisions that regulate the conduct of annual general meetings, or AGMs. These provisions are crucial for ensuring transparency, accountability, and shareholder participation in a company's decision-making process. The Act mandates that every company registered in India must hold an AGM. It outlines the requirements for convening, conducting, and concluding these meetings. This includes specifying the time frame for holding AGMs, the procedure for sending notices, and the quorum requirements for valid decision-making. Furthermore, the Act defines the roles and responsibilities of key participants in an AGM. This includes the chairperson, directors, and shareholders. It also outlines the voting rights of shareholders and the mechanisms for passing resolutions. By establishing a clear legal framework, the Companies Act 2013 ensures that AGMs are conducted in a structured and transparent manner. This, in turn, safeguards the interests of shareholders and promotes good corporate governance practices in India. Who must convene an AGM? Understanding the scope. The Companies Act 2013 mandates that every company registered in India must hold an annual general meeting, or AGM. This requirement applies to all types of companies, including private companies, public companies, and government companies. While the general rule is that every company must hold an AGM, there are a few exceptions. For instance, a one-person company, or OPC, is not required to hold an AGM. This exception recognizes the unique nature of OPCs, which are essentially companies with a single shareholder. Additionally, if all the members of a company agree, they can choose to pass a resolution through a circulation method instead of holding an AGM. However, this option is generally limited to routine or non-controversial matters. The requirement for holding AGMs ensures that all companies, with a few specific exceptions, provide a platform for shareholder participation and accountability. This fosters transparency and good corporate governance practices across the corporate landscape in India. The Companies Act 2013 provides a clear timeframe for holding the first and subsequent annual general meetings, or AGMs, for companies registered in India. Understanding this timeline is crucial for ensuring compliance with the legal requirements. A company must hold its first AGM within 9 months from the end of its first financial year. For instance, if a company's financial year ends on March 31st, 2024, its first AGM must be held by December 31st, 2024. Subsequent AGMs must be held once every year. The gap between two AGMs cannot exceed 15 months. This ensures that shareholders have a regular opportunity to engage with the company's management and exercise their rights. Adhering to the AGM timeline is essential for companies to maintain compliance with the Companies Act 2013. Failure to do so can result in penalties and legal consequences. The agenda of an annual general meeting, or AGM, outlines the key matters that will be discussed and voted upon during the meeting. This document is crucial as it sets the stage for the entire meeting, ensuring that all participants are aware of the topics to be covered. It serves as a roadmap for the proceedings, ensuring that all essential topics are addressed. By following the agenda, the meeting can proceed in an organized manner, preventing any important issues from being overlooked. Certain items are typically included in the AGM agenda as per the Companies Act 2013. These items are mandatory and must be discussed to comply with legal requirements. These include adoption of financial statements. Shareholders review and approve the company's financial statements for the preceding financial year. This is a critical step as it reflects the company's financial health and performance. This includes the balance sheet, profit and loss account, and cash flow statement. Each of these documents provides a different perspective on the company's financial status. Declaration of dividend. The Board of Directors proposes a dividend, if any, to be paid to shareholders. This proposal is based on the company's profitability and future financial needs. Shareholders vote on whether to approve the proposed dividend. Their decision impacts the distribution of profits and the company's retained earnings. Appointment of auditors. Shareholders appoint or reappoint auditors to audit the company's accounts for the upcoming financial year. This ensures transparency and accuracy in financial reporting. Appointment and remuneration of directors. Shareholders appoint or reappoint directors and determine their remuneration. This is vital for maintaining effective leadership and governance. In addition to these mandatory items, the agenda can include other matters that require shareholder approval. These additional items can vary depending on the company's specific needs and circumstances. This might involve changes to the company's articles of association, the issuance of new shares, or major investments. Each of these decisions can significantly impact the company's future direction and strategy. The agenda ensures that all important matters are brought to the attention of shareholders, allowing them to make informed decisions. It provides a structured approach to discussing and resolving key issues. It also helps to keep the AGM focused and efficient. By adhering to the agenda, the meeting can be conducted in a timely manner, respecting everyone's time and contributions. The Companies Act 2013 mandates a specific notice period for annual general meetings, or AGMs, to ensure that shareholders have adequate time to prepare for the meeting. This legal requirement is designed to promote fairness and transparency within corporate governance. This notice period allows shareholders to review relevant documents, understand the agenda items, and formulate their questions or concerns. It provides them with the opportunity to seek clarifications and gather any additional information they might need. For an AGM, the company must send out a notice to all shareholders at least 21 days before the date of the meeting. This ensures that shareholders have a sufficient window to make travel arrangements if necessary and to adjust their schedules accordingly. This 21-day period is crucial for shareholders to make informed decisions on the matters to be discussed at the AGM. It allows them to deliberate on the agenda items and consult with advisors or other shareholders if needed. The notice can be delivered to shareholders through various means, including registered post, sending the notice by registered post to the shareholder's registered address. This traditional method ensures that the notice is received in a secure and verifiable manner. Email, delivering the notice electronically to the shareholder's registered email address. This method is efficient and environmentally friendly, ensuring quick delivery. courier, sending the notice through a reputable courier service to the shareholder's registered address. This method combines speed with reliability, ensuring timely receipt. Website publication. Publishing the notice on the company's website, provided the shareholder has consented to receive notices electronically. This method is convenient for shareholders who prefer digital communication. The notice must contain all the essential details of the AGM, including the date, time, venue, and the complete agenda. It should be clear and comprehensive to avoid any confusion. It should also include instructions on how shareholders can participate in the meeting, vote on resolutions, and appoint proxies if they are unable to attend in person. This ensures that all shareholders have the opportunity to be involved, even if they cannot be physically present. Ensuring timely delivery of a comprehensive notice is crucial for facilitating shareholder participation and upholding the principles of transparency and good corporate governance. It reflects the company's commitment to engaging with its shareholders and maintaining an open line of communication.